Lawyers want the state government to simplify its controversial sex offender provisions. Legislation could be rewritten after the Court of Appeal released notorious sex offender Robert John Fardin and ruled new laws invalid.
Fardin's release was a double blow for the Attorney-General. Jarrod Bleijie didn't want the serial rapist out, and the Court of Appeal scuttled his backup plan to invoke the new Public Interest Declarations Bill. That was the controversial amendment that would have let the government detain Fardin without court approval.
It's not dead and buried yet. If it can be revived, we certainly will.
That means appealing to the High Court or rewriting the bill.
If there's no action available, then we will certainly look at the declarations legislation to revive it in some form or another to make sure we capture the likes of these serial sex offenders.
The Bar Association never supported the declaration's power, and the Law Society urges the Attorney-General to consult more this time.
Perhaps with consultation, genuine consultation, some of the shortcomings with the legislation might have been ironed out.
Rather than go back to the drawing boards, this arrogant Attorney-General should just go.
As well as having another go at the Public Interest Declarations Act, the Attorney-General will also review the other law, the Dangerous Prisoners Sexual Offenders Act, the one that wasn't able to keep Fardin in jail any longer. Mr Bleijie wants to make it tougher for courts to release prisoners and require more of them to wear GPS bracelets if they do get out.
I would suggest at the end of the review you'll see a lot more sex offenders in this state wearing GPS monitoring devices.
But the Law Society wants a simpler solution.
So that we end up with one piece of legislation that governs all of the issues rather than these ad hoc pieces of legislation being drafted.
Parliament has risen for the year, so amended amendments will have to wait until early 2014. Chris O'Brien, ABC News, Brisbane.